Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning. It is another day in the Karen Reed trial. Welcome you all from being here this morning. Sandy B, new member. Okay, well, welcome a new member. And hi, Oasis Cats Monitoring. And hello, Priscilla Thompson. Hello, Krista Limited Edition. Thank you all for being here. And I know we're going to grow as we go along. We are monitoring the courtroom. Good morning, Oasis Cat. Yes, we are monitoring the courtroom. And I don't see a fan. The funny thing is now I see a light. So we have gone from that rotating fan to seeing a light there in the courtroom. So they're up, they're running, whether or not the attorneys are in the courtroom, anyone's in the courtroom, we'll see. Today is going to be an interesting day because there are going to be motions that are being argued. And these should be, well, obviously things that need to be done before the opening statements. And we know what two of them are. And that is both cross motions. I just have the covers right here. We showed them a little last night. It is the Commonwealth's motion for notice of any visual aids, potential exhibits, or potential chalks that will be displayed to the jury during opening statements. They're actually telling us they're going to do that, but they also want whatever the defense is using. So the defense filed a motion. Defendant's motion and notice that the defendant intends to display visual aids to the jury during opening statements. So we are about to find out, I think, what these are going to be. Now, the judge is going to say, have you shown these to each of the parties, Mr. Brennan, Mr. Jackson, or Mr. Yannetti, or whoever is handling the chalk issue? And remember, the reason why we say chalk is in Massachusetts, anything that is not going into the jury room, that is a piece of evidence, or anything that we would call in other states a demonstrative exhibit in Massachusetts is called chalk. I guess for and from the old time blackboards, you know, the chalk on the blackboard. Oh, I just get the chills just thinking about it. Or you wrote on a board and then you erased it. And that was your demonstrative exhibit, your explanations to a jury. It is called chalk. Okay. So, that is where we are. Again, we'll see what else is happening. Now, we happen to know that there's other motions out there, right? We know that the Commonwealth still has a motion for, they want a hearing before any of the ARCA experts testify, and that is the private company that was hired by the federal government to investigate whether Officer John O'Keefe was hit by a motor vehicle, specifically the motor vehicle of our alleged defendant right here, Karen Reed. All right. And the investigation ended with over 3,000 pages that you and I have not seen, but that both the defense and the prosecution received as a result of something called writing to the government and asking for these exhibits. It's called a TUOHY letter, TUOHY. And the government gave over because they had said they had finished whatever investigation they were doing. And we don't know what the actual scope was. We don't know what is this your job to see whether there's corruption, or is this your job to see whether she was hit, or is this your job to see whether evidence is found? We don't know that. But we do know that ARCA was hired for one specific reason, and that was to see whether or not this car, the SUV, or any motor vehicle, I gather, could have caused the injuries to John O'Keefe that eventually resulted in his death. And I say that because it wasn't just the injury to the back of the skull. The medical examiner has the cause of death as being also hypothermia. That is, he died in the cold. Your temperatures became too low and you died. He also had, John O'Keefe also had, as we know, a 2-inch fracture to the back of his head. He did not have any broken bones, injuries, or anything to the front of his body. He did, as you know, have injuries to his arm that apparently ARCA did not attribute those in any way to an automobile strike. So that's why they were hired. And the prosecution now, because of the issues that were created at trial, that still has to be decided. And I think the judge has already said before ARCA testifies, she is going to have another limited voir dire hearing. So whether or not we're going to get into that today, I don't know. And Kerfuffle, your name is pretty good for what this all is going to happen in the courtroom. Is it going to be heated? Is it going to be that they actually, by the way, I'm now seeing that fan running around. So we're getting closer. We've moved from the light to the fan. The next thing we should probably be moving into is into the judge taking the bench and the parties arguing whatever motions there are left. Now, we all know that as trial lawyers, that when you get to this stage, there's also something called housekeeping motions, housekeeping issues. And what those are whatever the attorneys want to bring up. And we'll see. And, as we know, this is not going to be a trial one with Mr. Lowley, who is seated at counsel table for the prosecution next to Hank Brennan, but really hasn't done anything. We know that Hank Brennan is tough. He is rough. And I think we're even going to start seeing some of that today in whatever motions we have left. Now, why this day is important is because this is the last day, supposedly, the parties are going to be in court. Court has a holiday on Monday. It's Patriots' Day in Massachusetts, so holiday. And Thursday and Friday, she said there is no court. Now, that's probably good news because I can tell you that this judge has had these lawyers in court, and it doesn't affect the prosecution as much because there's 600 or 1,000 or whatever people in that office or support staff and all who is behind Hank Brennan. He can just say, I want a list created, and a list is created. But the defense has what you see there, plus they have law students working for them. But it's not, the defense, despite what people say, never have the resources of the state. They don't have all those investigators. And they've been in court when they have to prepare for a new trial. And it's not just a repeat of the old trial because you're going to have transcripts of that first trial. There's going to be impeachment. You have to be ready. There's arguments again over ARCA, all sorts of things that has gone on. So let me tell you that that's going to be a number of the issues. And apparently there are some new filings that we are going to hear from, besides the motions in limine, besides the motions for exhibits, okay, all of that. So, we have all of that going on with regard to the motions that are going to be argued today. And there will be new ones that will be brought up, okay? By the way, hello, Kathy Bettis, is it? From Wyoming. Beautiful, beautiful state in Wyoming. Thank you for joining us. And, you're absolutely right. Joanne Jetta-Platypus, right? M. Jetta-Platypus. What puzzles me is that there's no evidence of bruising to John's body or legs. If hit by a vehicle, there surely would be. Yeah, that's what we're all saying. As anyone in our new time, by the way, Sue says it's 10:30. We kind of figured that they were going to be a little bit late, but we have a lot to talk about. Has anyone in our chat seen somebody hit by a car at a motor vehicle accident? I have. And it's you hear it, you see it, you never forget it. And yes, a SUV of that size, and we all drive our cars. There's no bruising in the front. There's no broken bones in the front of O'Keefe's body. One of the things I do have to say is I do think the defense this time should concentrate a little bit more on that. All right. Hey, ladies and gentlemen of the jury, you do not have a manner of death here. And you have a cause of death that doesn't have any injuries that equate with a motor vehicle strike to the front of the body. And that's the prosecution's case. You have none. The prosecution cannot prove beyond a reasonable doubt that the SUV hit John O'Keefe. Simply can't. Without that, there is no homicide that's able to be proved. And the state tries to go around that. How do they try to go around that? They try to hire other experts that aren't even medical examiners. They don't want to bring in another forensic pathologist. What they do is they try to hire other experts, a brain injury expert from Florida who makes money doing surgeries by injuries to the brain. He runs a center. He is not even qualified to give a manner of death in the state of Florida, and he's certainly not qualified to give a manner of death in the state of Massachusetts, but they're trying to get around it because their experts said that they cannot say that the death was caused by a motor vehicle strike, especially a motor vehicle strike by Karen Reed. And that's what you have going on here, ladies and gentlemen. So why are they trying to do this? Well, that's where the defense then comes in with their conspiracy theory. I had another theory with regard to that. But let me answer a question that's going on. So, Linda, please explain, not for the truth of the matter. That has to do with hearsay. Okay, so hearsay is a statement that you relay in court that is either said by somebody else or given to you by somebody else, or something that you relate that you have not seen. All right. But hearsay, and the reason why it's called hearsay, okay? You hear somebody and you're saying what somebody told you. But there are so many exemptions to it. And courts generally have enforced this rule on the basis that hearsay may not be reliable, right? Okay. But in the way of the world, and you all know it, why you talk to people, right? You say, I heard that, I heard this, I heard that. There's usually some truth to it, maybe not all the time. But for instance, a 911 call, all right? A 911 call, when someone gets in and says they have a 911 call, a 911 call is actually hearsay, right? Why? Because the person taking the call is then repeating to another officer, you have to go to, 34 Fairview, right? But it's hearsay. So generally, in many states, believe it or not, a 911 call, the subject of it is not introduced by a 911 operator. Many states are very strict and say it's hearsay. Other states will say, well, it's not being introduced for the truth of the matter, what is being said. It's being introduced to show what happened and why people did things, or there was an excited utterance in a hearsay call, and that excited utterance could be reliable. So they say, not for the truth of the matter. So, officer, you got to report that there was a car strike at 34 Fairview. Objection. Why? Well, you just mentioned hearsay. So the question really becomes, officer, as a result of the phone call that you received, without saying what it is, what did you do? All right. And that's a way around the hearsay. And then you have to bring in the person who actually told the officer what the officer was going to say. This is just an example. So, but to get around it, they say, well, this is not being offered for the truth of the matter. This is being offered to explain why somebody did something, why an officer did something, why a person did something. So that's why you always hear it's not being offered for the truth of the matter. But quite frankly, when you hear it, what goes in your mind? Well, it does seem like it's being offered for the truth of the matter, because juries and all of us have a hard time distinguishing in the real life what goes on. And I did ask the question, did anyone see? Michelle did answer, I did. And did anyone see anyone get hit by a car strike? I did, and I could not unsee that. And it was in 2008. Two ladies holding hands in their 50s were crossing the street when a Corvette went speeding through the light, took out one of the women. Right. You see it, you hear it, it's awful. But you see it and you hear it. Okay, hearing is another thing. And when you have that strike, think about when anything hits you normally, or you bump into something. Right, I bump into the corner of my desk here. Right, I bump into this with my arms. I may bump into it so hard, I have bruising, and that's not a 2,000 pound or 4,000 pound, depending of the nature of the automobile or the SUV, how big it is, hitting you at supposedly 35 or 40 miles an hour. I can't imagine, just as a lay witness, a lay expert, a lay person who drives a car, being hit by a large SUV at 35 or 40 miles an hour, and having no injuries to the front of my body where I'm hit. Okay, I just can't imagine that. And I think the defense has to concentrate on that more. They've concentrated on this conspiracy. Well, maybe the conspiracy was that John O'Keefe didn't die by the car strike. Maybe he was drunk. Maybe he fell down. Maybe he hit his head. He died in the snow. And I can see a conspiracy. You're in the Alpert's house, and you find that there's a dead body on your front lawn, and you think, oh my gosh, I am going to get blamed for this. Why didn't I go and check? Why didn't I do anything? He was supposed to come in the house. So maybe the conspiracy is a conspiracy to cover up something, because you thought that maybe you would be blamed for the death of somebody who died naturally because of some kind of fall out there, or some kind of hit out there, or whatever it was. But whatever it was, wasn't a car strike by the SUV. And I think what's happened is we have gone, through all of this. And, one of the things I worry about, I have to tell you, is that Hank Brennan's going to take a more limited approach to the second count. The murder count, to me, is ridiculous. I don't think, and I can't imagine anyone really believing, although I do see it on Twitter, that Carney went out and purposely decided to kill John O'Keefe that night because she was angry, right? She certainly, if she decided to kill him, didn't think he was dead, because she called him like 50 times afterwards, screaming at him, right? But I just can't imagine that, okay? So, by the way, there apparently is a new motion. Defense has filed the pro hoc vici for Miss George. I quite frankly I'm going to go back and read it. I saw the heading, I saw the first page, but I thought that she was admitted in Massachusetts. So maybe she wasn't admitted in Massachusetts, and maybe everyone thought she was admitted in Massachusetts. So that's kind of interesting, because it says Victoria George from the Yannetti law firm and member in good standing of the Massachusetts Bar hereby moves to be added as local counsel for pro hoc vici for Alan Jackson, Elizabeth Little, and Robert Alessi. So even though she is an attorney licensed in good standing, on September 22nd, Alan Jackson and Elizabeth Little were given a pro hoc vici to represent Karen Reed in this matter. And since Victoria George is now part of the Yannetti criminal defense law firm, where she's been for a while, she's prepared to serve as additional local counsel for Alan Jackson, Elizabeth Little, and Robert Alessi. A good cause exists to grant this motion because Alan Jackson, Elizabeth Attorney Little, and Attorney Alessi have specialized knowledge of regard to that. Counsel has paid the overseers a board registration of $355 per attorney. That's for the people that are pro hoc vici. So they're asking to admit her as local counsel. Let me tell you, this must be a Massachusetts rule, because since Yannetti has sponsored through his law firm, Alessi, Little, Alan Jackson, I guess that what Massachusetts does is say that's a personal sponsorship. And now, since indeed Miss George has already been added as part of the defense team, and since she works for Yannetti, she now also personally can represent that she is sponsoring them. Quite frankly, it's ridiculous. All right. Why do you need that? They're already admitted she's part of the firm. In no other state would you need a separate sponsor from a law firm to sponsor an attorney who's already been sponsored in. All right. But that's a new filing. And apparently, again, it's one of these housekeeping motions. I don't think that there's any chance that Mr. Yannetti is going to get knocked from the case. Now, if Mr. Yannetti were local counsel and he were going to leave the case, or he were local counsel and he were going to be removed from the case from the judge by a judge, then of course it would be wise to have his associate, Victoria George, be local counsel and sponsor the pro hoc vices, which you have to do of counsel from out of state. So I don't think they're worried about that. So I assume this is another one of these niceties that Alan Jackson, Robert Alessi, Elizabeth Little need to have a second sponsor just in case something happens. So that's great. Now, Jason Hodges also points out, hi, Micah, by the way, how's your mug? That Karen's tires could have been spinning in the snow, making it look like she was going fast in the driveway. Yeah, well, I could think of a number, and I've said them on this thing, that maybe he got scared that he saw tires spinning and fell backwards. I don't know. Maybe he fell backwards and then tried to get up and he was drunk and he fell again. I don't know. All I can tell you is that he died from having a fracture in the back of his head, which is not compatible with the car strike. And he died from the hypothermia. So is Hank Brennan going to say that he was scared? Well, who's going to testify to that? That's the problem. Who's going to testify to that, right? That's simply the problem you have. Now, thank you, Oasis Cat. Yes, sponsor us all, by the way, by hitting this like button, because we're going to be with you through this whole hearing here. But so I think we've answered the question about Victoria George and her having to also be admitted as a sponsor by the court. And so she sponsors the attorneys. So now they have two sponsors. Really very interesting. Somebody pointed out, by the way, having nothing to do with this case, in legal news of yesterday, that Brian Steele did join Sean Combs' legal team. Yes, he did, and no doubt about that. There was rumors that Mark Garagos was going to join. There were rumors that Joe Tacopino was going to join, and instead we see Brian Steele. Well, I'll tell you what, we all watched Brian Steele. He's going to be a formidable person with regard to the Diddy Combs, which is going to be going on at the same time as Karen Reed, by the way. So that's going to be another issue. And we also know, by the way, that today, just while we're waiting for this, there's also going to be the selection of jury selection starting in Harvey Weinstein 2. And Michael Bryant is heading out, is going to be heading down to 100 Center Street. By the way, and I get incensed over this, where he does have a press pass for Justice Serve TV, 100 Center Street, this been on TV forever, some of the biggest trials there forever. And he will check for us on jury selection and what's happening there. If you want to see the interview we did with Arthur Aidala and Nimrod Ansari the other day, it's on our Justice Serve TV page, because they are prepping Harvey Weinstein to testify. Now, whether he testifies or not, it's a different story. But it'll be interesting to see how the jury may be different this time, both in how they're reacting to Harvey Weinstein. And as Arthur Aidala points out, a lot has happened since Harvey Weinstein was last sentenced in the New York case, which was overturned because the court, our court, High Court, it's not we don't call it a Supreme Court, but it's kind of like Massachusetts. It's our High Court that we call something else, has ruled he didn't get a fair trial, that the judge let in all the stuff that made it seem like he was a bad person. He was terrible at a restaurant to a waiter and things like that. and that it was not a fair trial at all. And the three most serious counts in that trial, by the way, as Arthur points out, there was a not guilty verdict, three most serious counts, but leading to now a retrial on some of these other counts that he was convicted on, some of these lesser counts, and we shall see. So that's going to be another interesting thing. We're going to get reports today from our own Michael Bryant, and tomorrow night we expect to have reports on from somebody else who's going to be in that court of more in common, who will be covering that case. So we expect to follow that case for all of you. As you know, I was hired by Jose Baez and Ron Sullivan for a period of time in that case, to answer some legal questions they have, to give them some legal advice and my opinion on things. But as a result of doing that, I did have a number of interactions with Harvey Weinstein, and those interactions would be privileged as if they are attorney-client privileged, because they essentially are, because Ron and Jose were the actual attorneys of record in the court case. I never filed an appearance because I was not appearing in court. I was giving legal advice on certain issues, which issues that obviously I don't have authorization to tell you now. But I've disclosed this when I was at Law and Crime. I've disclosed this here. I can tell you that's going to be very interesting. Me personally, as someone who met Harvey and spent a lot of time with him, even alone in his office, since I had to do interviews so I could give my personal advice to Jose and Ron. I was never scared of him, but that doesn't mean that women weren't assaulted or not. But that doesn't mean whatever the situation, he shouldn't have a fair trial. So we're going to be covering that today also, just so you also know. And now, yes, I'd like to be flies on the wall of everything. Joanne says Harvey creeps me out. It was really interesting. I had no problems with Harvey. He was always very solicitous in terms of making sure I had everything I needed, answered all my questions, making sure I ate well, had food, anything. So I never had any issues with him. But of course, I'm acting in a different capacity when I met with him. It's going to be, by the way, interesting as we wait to see what's happening here. As you say, we know three motions. We know the one motion of Victoria George now to pro hoc vice in, not that Mr. Yannetti wasn't enough, but pro hoc vice and all the out-of-state attorneys. That's just going to be pro forma, I think. That shouldn't be really a substantive motion. I think we are going to get into some things with regard to the chalks that the parties are going to be using here, right? That both the defense and the prosecution want to be using. Now, it's unusual in Massachusetts. You have to file this because the general rule in Massachusetts is you do not get to use chalks. We tried to use chalks when we were in Hernandez, and the judge said, no, sorry. In opening statements, things are not in evidence yet. Nothing is evidence yet. I don't care whether the parties agree that something is going to be in evidence. You are not going to be using chalks, demonstrative exhibits. Apparently, this judge is going to allow it. And apparently, she's going to allow Hank Brennan to use the statements, or some of them or all of them, that he filed a motion on just the other day, that he wants to use Karen Reed statements that she made to the media. And she said, come at me. She said, come at me, by the way. She said there is simply nothing that she would have said to the media that she wouldn't say have any problem being represented in court. And I believe the prosecution and defense have agreed that the statements that the prosecution have put in that they're going to use in trial, that I think they've agreed that those are true and accurate statements. The question is going to be, can you use them in an opening without the context of having a completeness? Because when you're in a trial, you may hear Alan Jackson say, yeah, we've agreed those are true, but we want to put in additional statements so that when those go in, they are complete. They're in their entirety. They're in the context. So we'll see if there's going to be a fight on this here in the courtroom here today. And we'll see. We haven't seen, and apparently neither side has seen the chalks of the other side. The judge is going to say, get together and show them to you. I want to get together. I don't want anyone to be surprised. I don't want to be here Tuesday morning and you all still fighting over what you're going to show to that jury when I start on Tuesday, whatever time I start. But I'll guarantee you there's still going to be issues, because that's the way trials go. Things come up. If you don't think things are going to come up between now and Tuesday, and also, I want to know about the jury. The jury, every time the jury was in, right, we kept losing people. Did we lose anybody overnight, even though they're not in today? Have they called and said, ring a ding ding, I can't serve? And the other question I had, I put it on Twitter, and there's probably no answer that you can give me, only one of the teams can give me, is I wanted to know whether we reached 18 people because everybody ran out of preemptory challenges, and those are the challenges you can use for any reason, no reason, as long as it's not an illegal reason like race bias or some type of bias, right? Right? I wanted to know that, because I want to know if the 18 we got to was really because everyone was satisfied with the jury, or because no one had any challenges left to remove anyone else who would come up and replace anyone in that jury. Okay, so that was some of the, and apparently somebody picked it up and said, no, obviously, right now, you can't, no one can tell you that. Why? Because the attorneys are gagged. So if Karen Reed wants to come out and say it, we could only probably hear it from her, because the judge is not going to say it. And usually, let's say you're the defense and you run out of challenges and the prosecution has challenges. You may say you're satisfied with the jury because, and the court allows that because the court doesn't want anyone to know that you've run out of challenges. And then if, let's say, the prosecution could remove somebody and put somebody in because they still had preemptory challenges. So it makes a difference in whether or not either side was satisfied if they ran out of challenges and then somebody, what we call, ran the table with any challenges they had left to get people that they felt were closer to whatever they believed. And usually it'd be the prosecution who has challenges left. Usually the defense will use their challenges first. You have to be very careful. And if you're a member of a defense team, you know that you always try to save that one final challenge, because you're trying to get the jury that you can live with, that will listen to your case, even though they may not be the people that you really necessarily want. But you want to always save that one last challenge for somebody who you know is really against you, that you have to use it. In the old days, because of the popularity of like the Lone Ranger and all, they used to call it the silver bullet challenge, that you just say that because that's going to be the one that you need to get off the jury, because that person is definitely against you. So jury selection is really an art in of itself. If you, by the way, Missy Mayhem says, I love this, we still have OnlyFan in the court. Sigh. Well, that's a great OnlyFan. There should be we should have fans from now on. Look at everybody's fans in the courtroom and have a contest. Well, who has the best fan in the courtroom? Micah says, since I had the poster, the actual for the Spectre written by David Mamet, everyone signed it over here, by the way, on mine here. Did you ever tell us how Glengarry gets Ross was? Always be closing. It was great. I mean, obviously you have three fabulous stars in there. It was absolutely terrific. Anyone doesn't know, it's the famous play written by David Mamet in the 70s, won his first Pulitzer Prize on. It was simply fabulous, Micah. I'd recommend it before it goes out. And you have just everybody in it. Everybody meaning like a cast of like 7, but still was really terrific. So let's see what else we can talk about. Bill Burr delivered. Bill Burr not only delivered, he was amazing. And I'm watching him doing all these TV interviews now, and too, as I see him, and I say, oh my goodness, it was incredible. But anyone who knows the play, ABC, always be closing. So that applies for everything in life, I guess. Always be closing. Always have a point to what you're doing. We're always be closing here, right? We're all closing to tell you what's happening in court, right? So that's what we want. Who has specific questions about what may else happen today besides the fact that they are late, right? Of course. And I don't know if they're late because they are in the judge's chambers, if somebody is late because they're just late. What the heck is happening here in there? I mean, we don't have a jury today, so that's the good news, right? We don't have a jury, so the judge can't say we have a jury waiting and, whatever. So that's the good news about that. Are they bringing in their chalks? Are they going through their chalks, right? And trying to get some of these things out of the way privately? What do you think? What do you think is happening in the court? Who do you think is going to argue for things today? You think it's going to be Jackson? Do you think, And again, what I wanted to say is that I really think it's unfair the judges kept these attorneys in trial, not in trial, in the courtroom in this case, for all this stuff. They've had hearings, they've had motions. I mean, they all look tired already, all right? Really, they all look tired already. You're trying to prepare for a case. You're trying to give your client the best representation you have. And again, I don't think this generally applies to prosecution because they have a lot of people in the background to do lists and all. But for a defense team, when you've got to do, you have no idea how much work, even if you've done it before, work getting an opening statement is. You want to get your closing statement pretty much ready as your opening statement, because your opening statement is going to track your closing statement, right? Your closing argument. It's called an opening statement and a closing argument, because in an opening statement, you're not supposed to be arguing your case, although, we get close to the line, but you're supposed to be setting out your case for what you expect the jury to be here. So a lot of times, you'll hear someone will make a statement of fact and there'll be objection, and the judge will say, you can put that couch that in terms of what you expect the statement to be or what the jury will hear. So then you'll hear everyone say, I expect that there'll be testimony that. I expect there'll be testimony that. And I hate those kind of opening statements. One of the things I always try to tell when I open to the jury is, look, this is what I expect the testimony to be. I'm not going to repeat this line over and over again, because everything I say is what I expect the testimony to be is going to be coming from that stand in that courtroom, blah, 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 blah. To try to avoid that, an attorney saying that line over and over again. Now, one of the things, by the way, Mike, I did not say that not only was Bill Burr fabulous, Kieran Culkin was amazing. He actually cut his hand on one of the scenes in when we were there, and we saw in another scene. It was all wrapped up because he hit a interesting. Now that you say that, he hit like a metal desk that they were using, old time metal desks, and he hit it so hard when he went down that his hand got cut and bled, right? And it was a blunt impact, and he obviously had an injury from the blunt impact, right? There. And the injury was right there where the blunt impact was, right? So interesting about that you say that, because those are the things that we in our regular life look at to make sure when we evaluate testimony about whether or not the jury will find beyond a reasonable doubt that a car, an SUV, a vehicle caused the death of John O'Keefe, caused him to get into that snow and then have the hypothermia. An impact, a vehicle strike, we use our common sense. So yes, Missy Mayhem says she loves Kieran Culkin. It was also Bob Odenkirk was in there too. And then there was a couple people there was actually one of the cast members that was just also fabulous. It was John Pieruccello. And if John Pieruccello was actually in the Spectre movie, David likes to use actors that he's used to. And if you go watch the movie, you'll see that whenever Helen Mirren was being driven around, she had, I'm not going to say a sidekick, she had somebody who was driving her around in Los Angeles, and it was John Pieruccello who played the role of this investigator that was with, allegedly me, driving Helen Mirren around. So that was, it was really interesting to see John, in the play too, because he was also terrific. Everybody in the play was terrific. But Kieran Culkin had just come off his award for his Academy Award win, his Golden Globe win for last year for Succession, all sorts of things too. His Emmy for Succession, I guess, and the Golden Globe, and the Academy Award for A Real Pain. And he played Kieran Culkin. I mean, he played Kieran Culkin, so. But I digress, because always be closing. That kind of applies to how you deal with a case, right? When you open, you have to remember, always be closing. You have to remember what your closing is going to be. So this is why that ABC line has become, I think, so popular, so important, because it applies to everything. And it certainly applies to trials. Always be closing. You're always thinking about a case. And everything that you do in a case, if you're a defense attorney, by the way, has to go to your theme of the case. You shouldn't have one question. You shouldn't have one witness that does not support your theme, that does not go to your ultimate issue that you're arguing for that jury. And when we expect, by the way, openings to be, I think we've been told that Alan Jackson will be giving the opening this time. And the closing will be David Yannetti. They reversed. So I expect and we're going to do this, by the way, on Justice Serve TV. We're actually going to tape tomorrow the openings of both Lowley. We're going to tape a show about the openings of Lowley and Yannetti, and we're going to run them as a premiere on Monday in anticipation of the trial on Tuesday. On Thursday night, though, this week, we will go through the closing statement of Alan Jackson on our normal 6 p.m. Time, and we will see what we can glean about how his opening will be, or maybe how his opening shall change given what's happened. And the problem you have here is you don't know if this judge is going to allow the ARCA people. Remember, last time the ARCA people couldn't testify as to what caused the death because they weren't medical experts. And that happens, by the way. I know the judge Canoni took a lot of heat for that, but that happens in a lot of cases. Medical examiners, forensic pathologists, by the way, are in the state. The actual medical examiner is the one who could only sign a cause of death, on a matter of death, on a death certificate, unless you are a treating physician and it's not a suspicious death. If it goes to medical examiner suspicious death, no one else can actually sign that death certificate. If you are a treating physician and it's not suspicious, then of course you can. We all see that in our regular life, right? So that's going to be an issue here, because now the prosecution has this brain expert from Florida, and he's going to apparently opine upon the manner of death by talking about his cause of death, and try to get around by talking about the cause of death, somehow opining on the manner of death without actually saying what the manner of death is. And now we also have a dog bite expert that's going to talk about it. So I don't know that the judge prevented the ARCA people from mentioning it at the first trial. Seems to have gone bye-bye now, that she's going to allow the prosecution to allow a dog bite person to talk about cause of death and manner of death, apparently. And I still think there's going to be fights over that. Big fights over that. And, what you have to remember, if you're a prosecutor, I know Hank Brennan likes to go all out from what we've seen, is that even when you get a conviction, a la Harvey Weinstein, you have to then uphold that conviction on appeal. And I've heard prosecutors say, well, we'll get the conviction, they'll do time in jail, that's what we need. That's what we need. That's the first step. That really is not the step that you should be taking as a prosecutor. Your step should be, are you doing justice? Because your goal is to serve justice, or justice served, as we say. Your goal is for justice. It's not for winning. If you're a defense attorney, you have a different goal. Defense attorney their duty is just to your client. Okay. Now you have to do it within the rules of ethics, but your duty is only to your client. That's it. That's all it is. I mean, that's all we have. And when we take on the representation of a client, we can't be a wishy-washy about that. We take on that representation and we do the best job we can within the whole idea of ethics. All right. And that's very, very important. And you'll see, remember, I forget which case it was recently we saw, that one of the defense attorneys said they could not put somebody on the stand. If that person wanted to go on the stand, they had to go themselves, but they weren't going to question that person. And that was a hint to the judge that you knew that the client was going to lie and you can't be any part of it. But the client has a right to testify, and if the client wants to get up there and testify and question themselves, that's for them. I think it was the case in Florida, and I forget the name. You'll probably all remember the name. That the newspaper, maybe it was Las Vegas. I'm sorry, it was Las Vegas. A newspaper reporter was killed because he was doing a story on one of the people in Las Vegas, right? Oh, by the way, Oasis Cat says, I'll continue my story in a second. Aiden's motion will be heard this morning. We were asking that last night. After asking for 2 weeks for his attorney, got an email from the clerk, Jim, at 9:45 a.m. today. Aiden lives an hour away. He should be there around 11:15. Well, that's pretty outrageous. We kept asking last night on Justice Serve TV, we've been asking, when is Aiden Carney's motion going to be heard? Because we heard that Gretchen Voss, right? Everyone's agreed that she's exempt from the sequestration order. Aiden Carney, who really has been on this case, right? And been covering this case. And some will say has been indicted because he has been given coverage that the state does not, the Commonwealth does not like, because the state is called the Commonwealth of Massachusetts, just like chalks or chalks, not demonstrative exhibits. To get an email this morning that it's going to be decided. Well, Robert Tellis, Michael, you got that. Robert Tellis was the case. You're absolutely right. I'm going back and forth here, and I know you're following me because you all watch these cases. But yes, Aiden, we keep saying that should have been decided earlier. Absolutely. His name wasn't in the pool for the randomizer for this week because he forgot to put his name in. But he's got to have an exemption from the sequestration order because the state has put him on the list, the witness list. I can't imagine in any stretch of the imagination that Hank Brennan is calling Aiden Carney. And I did read that when he was a defense attorney, Hank Brennan was a defense attorney, he put people on the witness list that weren't going to testify, press, members of the press, and the 3 people in one case, again, to try to get them out of being in the courtroom and reporting. So if that was done, this is a game. But to get the idea that all of a sudden you get a 9:45, you get an email from the clerk that it's going to be heard today, well, then maybe it should be heard on Zoom. Come on. Today is your last day. You're going to be in court. Well, maybe the court should be open tomorrow. Maybe the court should have been open tomorrow for Aiden's hearing, a special hearing. But in my opinion, he should be exempt from that. Now, whether or not it's a good faith or not, whether or not he's going to be a witness or not, if he's going to be a witness, it's a witness to a very limited part of the trial. And if he is going to be a witness, it's not to most of the testimony that's going to be occurring. So we here at Justice Serve TV fully support the press here and the fact that any member of the press who gets put on the witness list should be exempt. Now, as you know, we didn't even get it. We first got an answer. We applied for a press pass. We first got an answer that Justice Serve TV, because our media, our journalism is streaming over YouTube, the largest streaming network in the world, where most people get their information, YouTube, social media, X, Twitter, right? That we weren't under the rules of Massachusetts entitled to a press pass. And then we went back at them and said, we're applied again because that's not what your rules say. Your rules say any medium. And we didn't even deign to hear us to get a press pass so we could be put in the randomizer. That, by the way, just so you all know, is a separate issue from the buffer zone because we're still media, we're still press. The press pass only gets you into the courtroom. It gets you into that randomizer, right? And you have a lot of people who apply for press passes, legacy media, who haven't been here covering the trial, haven't been with you, haven't been answering your questions, haven't been doing all this backup for the last 2 months, right? But we're with you. But so with Michael Bryant, when he goes next week, and he can't go, unfortunately, on opening statements. You know why? Family first on Tuesday, and he'll be landing on the red eye early that morning. But he will be there later that week. But when he goes down into the buffer zone to gather for news, he's still media, whether Massachusetts has given him a press pass to be in the courtroom or not. He's still media. He's still a journalist, whether Massachusetts court rules recognize him to be, because that's a very limited thing. That's recognition only to be in the courtroom that you get that press pass. By the way, and you all know, I see some movement here in the courtroom, by the way. So as soon as they go, we're going to go in. Oh, here we go. Let's see. Everyone is Judge Beverly Canoni. Okay, let's see if we can get sound. No sound yet, says Missy. Let's see whether we can be interesting, right? They're giving their names, and we still don't have sound. Well, Robert Leslie certainly jumped up there. He's certainly ready, good to go. Still no sound, Missy? On who's the streamer? Long Crime is streaming this. How about Court TV? Do they have sound? So as soon as we get this, we are going to give it to you. I'm watching all of your comments right now.
Laura McLaughlin.
There we go.
Good morning, Ms. McLaughlin.
Here we go. There we go.
Good morning, Mr. Lally.
So we're going backward just to see this a little bit.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information, and so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video in this case onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you. Mr. Brennan?
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing, it's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case. And it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view. She can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported the last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors, but just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see counsel at Sidebar about this anymore?
Okay, well, they go to Sidebar. Let's talk about that. Hank Brennan had objected to the SUV, Karen Reed's SUV, being at 34th Fairview, right? Now he's saying, well, the only reason he objected, I find this, quite frankly, and I'd love to have Hank Brennan on the show because he is a defense attorney when he finishes this. is he thought it would be highly prejudicial to the defense. How can you say it'd be highly prejudicial when the defense was asking for the SUV to be there? Because it gives you the spatial layout of how big the SUV was. So now he's saying if the defense wants it there, fine. The second thing that I find absolutely, and I'm going to tell you this, having done this a number of times, the Judge Canoni put it on the defense to say, how do you expect to get the logistics of Karen Reed being at the view, at the scene view? Usually, that's the court that works that out. Okay, it does not. It absolutely simply does not usually mean that you defense you give us a plan. Usually the court works it out. And the reason they have a problem here is she has an absolute 100% right to be at that jury view. That is part of the case. Absolutely part of the case. All right. That's being in the trial. There is no defendant that doesn't go to a jury view unless they're in custody. And your defense team chooses not to have them there because of all the sheriff's officers that are going to be around the person in custody. Here in Massachusetts, here in this courtroom, in this courthouse, they're putting the jury on the same bus with the defense. Now, when we did this in Hernandez, the jury was in a different bus. The jury went on their own bus. The defense went in their own bus, right? And all. You could have the defense and prosecutions in the same bus, but you didn't have the jury was in a separate bus. Usually, either with the judge or with one of the, and not even necessarily the judge, but with one of the officers that is responsible for making sure the jury doesn't see anything they should see. There is a state police transport. There can be shades on the bus. We did this in Hernandez in Massachusetts, all right? So I'm not talking as if I haven't been at court views where I've been in a number of cases, but where I've been one in Massachusetts. So the problem is, I think they're trying to save money here by having one bus instead of two, and therefore now the attorneys are going to be on the same bus with the jurors, and they want to know about Karen Reed. And so the defense head came up with a plan that, look, we'll transport the whole defense team and her in a separate car, and we'll come. And the judge said, well, that's not good enough, because then, you're going to have the prosecutors on the bus with the jurors. Well, that's created because you only have one bus. If you had two buses, that wouldn't be created. So she's allowing there be one member of the defense team that can go by car with Karen Reed to the site view, to the site visit, and all the members of the defense team, the other members of the defense team, along with the prosecution team and the jurors and the judge and probably the court reporter, will then be on the one bus. So that's how she's decided. Well, why would the defense need a plan if the judge already had a plan? If the judge already had an idea of how you do this, why would defense need to submit a plan? And then it's like, don't bother me with that plan. I really have a problem with the attitude there. I mean, you all know that I'm on the same program with just Canoni and Harvard and all. But that attitude right there was, again, it's showing an attitude against the defense that's kind of dismissive. And then we go back, as there's still a sidebar here, with regard to when the jury view will be, because apparently they want to keep it secret for the public. What? It's part of the proceeding. It shouldn't be secret. The press followed us around in Hernandez. They had to stay back a certain length. The press were there when we did Inspector in California. There was one member of the press who represented the whole press pool and all, and then she would report back, but the press could be around. People know when these jury views, and they should know. Now we're going to go back. We'll talk about the forensic issue on the downloads after.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list?
Apparently, we just
Is it
decided what the view was
erroneously on
going
the
to be,
list?
and we don't know what the answer is.
It's not erroneously,
Now we're
Your Honor,
on
but Mr. Brennan and I
Welcher.
spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is, okay?
I will do that.
All right, thank
Thank you,
you.
Your Honor.
Okay. So Lieutenant Wing.
Remember, Welcher is the brain expert. We'll talk
Docket
about that.
607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report, so that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
Thank you, Your Honor. With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it, for several years he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition. And the whole topic of pattern recognition was well established through Dr. Russell, so Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans. And we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with the wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear next.
This is a problem of
Understood.
audio
And I
coming
was
from
just
the court. not
going
us.
to say, I am not going to get into the basis for that. I just wanted to, because,
Just go ahead, just move on.
yeah, so my request would be that a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I'm found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others
Finally,
via bite
she
mark
got to
evidence.
what I've been talking
So,
about.
what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well-respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar, so it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. In here, there is definitive evidence.
I'm going to have a lot to say on
clearly
this because this
show
is
and
really
base an
standing
opinion
forensic science on his
that
head
the dog
incorrectly
named
and
Chloe was
outrageously.
not
We'll talk
the
about
cause
this
of those
later.
wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Wilson.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Did you want to reply?
Oh my gosh, she's going to let him reply? I mean, we have the experts. We could tell you this is the most ridiculous thing in the world. If this were a
simply
bite for a
suggest that
person,
there
it'd
is
be like
no
out.
authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you. The substitute chemist, is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids in giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's
I am,
going
Your
on?
Honor. We're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to the defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you. So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said they're just going to
yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you, so.
Thank you.
All right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay.
Can I make a note?
Yes,
So,
please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
But we could have somebody playing clothes from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial.
I don't
to
think somebody from
play
the state
that role.
police is an independent reader. Give me a break.
Yes.
Okay, Paula B. asked, why was there a sidebar when there's no jury? Because they want to keep secret, apparently, discussion about when this jury view is going to occur, which is ridiculous. Jury views are always told, the dates are always told to the public. I don't know why they want to keep it secret. I assume someone's going to file a motion that can't be done, that you can't be secret to, you follow the buses. Big deal, as long as there's no interference. I don't understand what's going on with regard to that. But that's why there was a sidebar. Okay, and Brooklyn.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively,
Okay.
we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found, if he's a state trooper, he found the text messages. He was the one who downloaded the data. He was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're their statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between 2 independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
There'll be no inflection. That would be inappropriate.
Thank you. All right, defendant's motion for specific discovery, paper 638, Jimmy. All right, who's arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say, as a preface, that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable, it applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay. I'll hear from the Commonwealth.
Oh, number 5? Oh, yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses. Motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we...
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but...
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed, so this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about, or respond after Attorney Jackson is done, about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is. They
So
desperately
address
does
number
not want-
one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th, about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that. If the court's satisfied with...
I have a question. It was my question last time when they testified. it wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rinchler talked about what he did, which was more on the biological side.
There was a difference
Right.
between the
And
two.
Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it, and it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well. But
Is there anything that they're going to say they cannot provide because of the federal investigation?
not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
Okay, so we have a little bit back and forth going on. Whoops.
Right.
I'm gonna talk to you, but we'll
Ms. Liu was-
continue in a bit.
I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes, that is on, that's on
Can
the
they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did, absolutely. That is on the table. Every bit of testing, every bit of analysis
But why they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counsel Sidebar, please?
Okay, another sidebar. Another sidebar. Let me just tell you that you can always tell the importance of emotion by whether or not lead counsel is now taking over. And I know the defense has said they don't identify or they don't say who they are by that identification, lead counsel. They consider themselves all lead counsel. But we all know that Alan Jackson is lead counsel in this case. I don't care what they say. And so he's arguing this ARCA motion. This ARCA motion has been the bane of the Commonwealth's existence. And it's the one that started all Judge Beverly Cannoni's, I believe, rancor that she feels against Alan Jackson, where she had grave concerns. So what we have going on here with the ARCA witnesses is Hank Brennan first started saying, by the way, that he did not have all of the discovery that he has been asking for, and apparently it's 13 points. The defense says they do have all the discovery, and then when they get it, they send it over. The defense further says, and this is the one thing that I'm not sure I agree with the defense, that they don't know what additional testing ARCA is doing, and they can't authorize them or to do. They don't want to interfere with their testing, and then when they get it, they will send it over. That I'm not sure I agree with. I think as a defense attorney representing a client, since now, as of the 26th of March of this year, the defense counsel received authority from the Department of Justice, and it took that long, to actually independently retain ARCA, because apparently they didn't have that authority from the DOJ. And as you know, the DOJ can work slowly, especially given the turnover now that we've had in the Trump administration and the changes of focus and all. But they received that. So I gather what they're saying is, look, we want them to be independent. We want their tests to be independent. We don't know what tests, the further tests they're doing based on what the Commonwealth has given us that we give them. And as soon as we get those tests, we give it over. The Commonwealth says, well, discovery is over. Well, discovery can't be over if you get new information from the Commonwealth that you're then giving to now defense experts that you could formally retain on the 25th of January. So, I mean, we know there's a little bit of ridiculousness here that's going on. And the judge says The judge then intervenes with a question. She says, she had a first one, but here's the second one. Second one's more important. I'm not sure who did what when each of the experts testified because they keep saying we. And what AJ said, Alan Jackson, is that, look, when each of them got on, they said what they each did. So when they say we, that's the common, right? It's the common way of talking. We, as the ARCA firm, here's what we did. She apparently wants them to say exactly what they did, but she's not yet ordered that, right? And so then she wants to know what they can testify to. And Alan Jackson says they can testify to everything they have done. That's totally on the table. They can testify to that. What they can't testify to is when they were hired by the feds, and apparently this goes all the way until March 26, 2025, what their directives were. In other words, what the scope of the work was as to why they were asked to do something. They can't do that. That is privilege, a federal communication, a federal investigation. So they can say what they did. So I don't know why she is, quite frankly, hung up on the we, because ARCA is as a company, it's an entity. And sometimes you may, as the head person, you may say to a subordinate, go do this, and then you rely on the data that's gathered, but then you make your own conclusions. She's apparently got some kind of issue with this, right? She's got some kind of issue with this, and that's what's going on right now. And, you know, she, as we know, when the defense paid ARCA last year, they got a bill after the trial, and apparently that was for the time of testifying at trial. The defense paid it immediately. Well, after they talked with the Department of Justice and said, can they pay this? And they said, yes. Apparently, that's where this all began, because, again, Hank Brennan has made an issue, and Judge Canoni has grabbed onto it like Chloe's teeth, had grabbed onto John O'Keefe, if you think that's the case, that somehow he lied to the court. That's what's going on there, right? And that, indeed, Alan Jackson misrepresented to her and the jury that ARCA was independent because he ended up paying them for the testimony afterwards. Well, to get a bill for your time and testimony afterwards doesn't mean they didn't do independent research and were hired by the Department of Justice. They're two separate issues, but sadly, they've been commingled. And I have to say, Hank Brennan's done a good job, right? He represents the Commonwealth. He's done a good job raising that issue and getting her not to trust Alan Jackson. And, so here that now she has him at sidebar on this issue of, well, then how can they testify as to what they did if you can't really, right? If you can't really say why they did it, all right? I think she should allow them to testify who they did it for. They did it for the federal government for an investigation. Ladies and gentlemen of the jury, this is what the judge would do. That investigation, ladies and gentlemen of the jury, is none of your concern. You have no concern as to what it was for, what it was done for at all. I'm going to order you now that you're listening to the witness. All you're concerned about is the fact that testing was done by an independent body that was not hired. They were not hired by the defense. And that's the only issue that you have. That's what you're not to consider anything else. That'd be a jury charge. That's what you give. It's not a big deal, right? It's just not a big deal. But she obviously has it as a big deal. She won't get off it. And this is why we're dealing with ARCA. Now, again, the one issue, though, I do that could get them in trouble, if Alan Jackson says he has no control over the experts testifying, so when what the experts are not testifying, what they're doing, and if they're doing any other test after March 25th, then, he can't control that. I think that's not great, because of course you can control that if they are your experts. Of course you can. And quite frankly, if they're doing testing and it doesn't come out necessarily good for your client, well, you may not have the person doing the testing who's in ARCA testify, but maybe ARCA is doing something else. Maybe it's a third scientist doing something else. So I think that's, everyone has a little bit of sway here, and I'll call it sway, as to what they're representing to the court. But so this is where we're at right now. The ARCA witnesses, can they testify? Again, Hank Brennan says that he wants that hearing to come the day before they're allowed to testify, to bring all the discovery, Alan Jackson says they have brought a discovery. They have no custody and control over anything else, but they bought everything that's given to them. And so I think to make an account, I think you're absolutely right. I think she has a problem with Alan Jackson. All right. And instead of just doing a jury charge, which would remedy it, because it's her problem, it's really not a problem with the evidence. It's not. If the ARCA did tests at the direction of the federal government, for whatever the reason, whatever their specific direction was, that should come in. That should come in if the jury is going to hear everything. And if you don't like the fact that Alan Jackson got a bill from them and paid them, well, tough. Let that be cross-examination, quite frankly. Let the jury hear everything that they can hear. But the one thing we know they can't hear is the feds have said you cannot hear any directives we gave to them. You cannot hear our discussions with them. You cannot hear that. We're giving you, that's it. So let's go back into this courtroom from hell right now.
All right, so Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when did you do?
We provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so?
Oh,
You
I
said-
didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
This is the very issue I've been concerned about since the beginning of this case. And I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern, and that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages.
I needed to be muted to
And
make
if
an
it
account
exists,
because
I would
was
like to
pretty
see it. I
intense.
think I'm entitled. The ARCA witnesses
I, as a defense
provided
attorney,
a
am
report
really
that blurs
pissed
the
off
roles
here.
of the parties. I
He
can
files a
live with that. I
Wexler
can
report,
accept that.
140
The ARCA witnesses
PowerPoint
provide a
slides,
report
goes out,
that
gets
does not
executive, and then he
have
doesn't want
a
the
lot of information
prosecution
about their study and notes.
report
I can
experts to go to
accept
the
that
defense and have
because I
them
have
respond.
prepared for
Give
it.
me a break.
But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the
Not only
Commonwealth's
that, he's
ability
the
and
one
right
who
to
wants
prepare.
the
It
hearing
creates a
before they testified
disadvantage
after the trial
that
started.
information
So
and
he
argument
creates
is
the
already
problem,
made to
and
the
then he's
jury
gonna say,
without
"Then
complete
you
information
defense,
that they
you can't
should have had.
your
They could have
defense."
retained
I've been saying,
any
I don't even
expert
wanna
they
listen
wanted. They
to
didn't
this,
have
but
to
I'm
wait
gonna
for
let
ARCA
you listen to
witnesses.
it because I'm
They've
so
had 3
angry
years. They
right
could have
now.
retained any accident reconstructions they wanted, but they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial.
This is a continued
They
pattern
have
of the
their ARCA
prosecution.
witnesses,
I'll
they
tell you what,
have their
I've been trying to be
report.
really fair in
That
this
is all
case,
pursuant to the
all right?
discovery
Because
deadline.
I do
To
think
now
Hans Brennan
let
is a
them
good
change
lawyer,
the
but I think
rules
this is slimy.
and come in tomorrow,
okay?
the next day, or
Because
10
if
days
you
from
can't
now,
respond as a defense attorney to a new report
and
that the
have new
prosecution
opinions
just gave
after
you,
we've already
what
told
you're
the
trying to
jury
do is you're
our theory
disingenuous.
and our science and not have a
Maybe the
chance
listener calls Judge
to
Beverly can
rebut
only
it or
grade
consider it.
concerns.
I'll have no
Come
time during
on.
trial to sit down with the experts and
I'll stop
assign them to
talking now.
review new
I'll talk
information, new
after.
reports.
Promise.
I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding
Okay, I lied.
discovery
I have to
of the
talk.
information that we
What
want.
do you
That's
mean you
what I asked
wanted
this court
ARCA to
do.
testify? You wanted ARCA not to testify. He's rewriting history. Okay,
Your Honor,
here goes AJ.
What appears to be feigned indignation is just not consistent with the facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025, by mid-March.
I think I just said all of this, so you see,
Asked for a two
I've been
request. We
practicing
asked
law
for
for a
a
little
two
bit.
permission, or asked permission to
Alan's
engage
being a
them
little
through a
bit
two
more,
request.
shall
That
we
does
say,
take time.
nice
We
about
did
it
it
than I'm being,
expeditiously.
because
We weren't
I can be
waiting
ranting from here.
for
He
some
has to do it in front of the court.
advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony, or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry. We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about certain things in the report, so we took things out of the report. There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided his CV in November, and then we provided on our discovery deadlines
Oh, CV,
January
real
31st,
important.
2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welcher's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier. So there is no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left the motion to sequester Aidan Carney to
That's
remove
it?
him from
We
the
don't hear anything,
sequestration
any
order.
ruling.
Is that the only
Now
thing
we're
that's now
gonna
left
have-
outstanding?
She's saying it's
No,
only
Your
thing
Honor,
left
there's
is Aidan
also a
Carney's
motion in limine that
attorneys.
was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to,
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach.
So this is the report. You can't have third-party
The
opinions,
defense
but you can have
vehemently
any
disagrees
statements.
with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I would like to be heard on that, Your Honor.
all right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Okay. So you guys in the chat, tell me, do you want to take a 5-minute break and then come back and talk about this? By the way, Brooklyn asked if we did any days. We didn't put in for the lottery because we weren't recognized as a getting a press pass. So we couldn't put in for the lottery for the randomizer, by the way. And by the way, why Yannetti just left, may I explain why we had that technical motion to have Ms. George sponsor the attorneys. He could have had another court date. A lot of times that happen. Another court will want you in court, or there's a personal matter that he has to deal with, the judge knows about. It's not on the record. And that's why then therefore that explains. I couldn't understand earlier today why we had that motion filed where that George now becomes a sponsor for the attorneys in court, because local counsel has to be in court all the time with the attorneys who are pro hoc vici. So that's why you had that very technical motion that really didn't mean much, didn't amount to much, that we discussed earlier, that Victoria George became sponsors for Yannetti and Jackson, Alessi and Little. And so because apparently there was some indication that Yannetti had a leave today, either another court appearance, some other thing, but they didn't put that on the record. But the judge knows what it is, and that's why it was no big deal. Probably everybody knew what it was. And that usually means it could be a personal matter that had to be dealt with, family matters, whatever. Anyhow, so that's why so we don't really need to talk about that anymore. But that's why it's a good question, Sue, because that's why it turns out that's why at least that motion was filed. Okay. So the question is, just give me do you want to take a 5-minute break and then come back and discuss this? We'll go mute for 5 minutes. I'll take a nature break, come back and talk about it, because I have a lot to say, and I muted myself a couple times because I wanted to mute myself because I wanted to get out how pissed off I was at the disingenuous arguments being made by the Commonwealth about Brennan. Okay, so we're going to take a 5-minute break. It's 12:16. I'll be back by 12:21 in this chair with you. Don't go away. All right. I think you are all here with me. Most of you, a couple of you left, about 20 of you left. As I was coming back and putting it in, yeah, we see that fan, right? We see that fan here, right? Good thing I took a little bit of a break because I'm really done with Hank. I mean, Hank Brennan, I've told you before, and I've defended him. He's a very good attorney. He's doing what the prosecutor of the county hired him to do, the DA, be a tough prosecutor, try a case. But I have this problem when any prosecutor, and he now has the ethical duties of being a prosecutor, when he gets up there and he says at the very end that he had he never tried to prevent ARCA from testifying. That was never his intention. I'm telling you right now, I believe that was always his intention. And if you believe anything else, really? Are you kidding me? I mean, of course he was. And then he says the court, he says something about, well, he gives a CV over. Thank you, Missy. I'm glad I'm back. I told you 5 minutes. CV over in last year, November, to make it sound, and the judge said something like, well, you provide things in November, to make it sound like she's supporting him. And this is what pisses me off about the judge here on this right now. And I'm going to say it because I've been very fair to her too. But we all know this is what Hank Brennan wants to do. Then he provides a report January 31st, probably late at night. The defense reads at the beginning of February. They don't provide the backup to the report to February 5th. And remind you, we're still getting videos. Remember, carport videos, Sally Port videos, and all that nonsense, right? And apparently, then he says, well, we just took out stuff because the defense objected, but it turns out there were additions. And remember, the defense has filed a motion to keep Dr. Welshler out. Welsher, this all revolves, what's happening here revolves around the defense providing this report of Dr. Welsher. Now, who is he? Remember, he's the guy from Florida who runs a clinic and he does all this gamma surgery with regard to the brain, making a fortune. And somehow the defense has found him because he's going to come in and he's going to talk about coup and contra coup injuries, trying to get around the two medical examiners, the one actual medical examiner who said this, she could not determine this was a homicide, and both medical examiners who said there was no evidence that an SUV backed into John O'Keefe and killed him. And also, she wouldn't allow, if you recall, ARCA to testify at the first trial that the SUV didn't cause the death of John O'Keefe because only a medical professional can do that. Okay, fine. Keep that ruling there as it is. I don't have much of a problem with that ruling as long as it applies across the board. I kind of like that ruling actually because it keeps people in their lane. But now the defense gets the permission from the feds to actually formally hire ARCA with a retainer agreement, not just pay them for the past testimony for a bill that occurs after trial that they didn't know they were getting, but formally hire them. They send them Welsh's stuff as they're getting it now, because they want him to respond. They want ARCA to respond to what the prosecution is now giving them just before trial. And so, and as they get stuff from the prosecution, they're going to then provide basically almost like a rebuttal report, right? It's going to be a rebuttal report. Now, here's what the judge actually could do. The judge could say, look, if it depends on how you present Wexler prosecution. If ARCA goes in the defense case and you present Wexler as a rebuttal, then we could have rebuttal, which is generally not allowed, but the judge could make an exemption for it here. But she's not going to do that because she doesn't do these kind of things. All right. But they want to have ARCA rebut. They want to have ARCA respond to Wexler to show that he's absolutely wrong. They want to have ARCA respond to all of this to show that they're wrong, right? And so if for Hank Brennan to say, this is what I've been worried about. This is since I came into this case that ARCA, we're going to have late discovery in ARCA. Well, you weren't going to have, you had to be worried about it because you knew, Hank Brennan, that you were going to go hire an expert, right? And then this expert was going to say something to try to undo ARCA, even in case you couldn't get the judge to go along with you with that bullshit about the defense didn't give you anything from ARCA, and it turns out that was wrong. You're the one who misrepresented to the court, right? You all know what I'm talking about. We can go through it, okay? We can go through it. And then if this is what you were worried about, you were worried about it, in my opinion, because you knew you were going to hire these people, and then you figured you'd cut the defense off at their kneecaps. I would say something else, but I am a lady, okay, and I'm not talking to my trial team. You cut the defense off at the kneecaps because you think you got the judge in your pocket because she's been ruling for you, right? Because you've created this kind of she doesn't trust Alan Jackson. You've got that vibe going. You want to cut them off at the kneecaps so that ARCA, if the judge allows him to testify, then can't testify in response to anything that Wexler has said. And it looks like Wexler's opinion goes unrebutted by the defense, all right? Because somehow under Discovery Rules 14, you defense are now late because of what I did, but you're the ones who are going to have to suffer. And I am really pissed off and angry about this. This is not how the process should work. Now, let me just tell you, part of this has been created by Judge Beverly Canoni by insisting that they started on this trial date, right, in April, picking the jury. She insisted she had to rush it, right? Instead of letting the prosecution give the documents over and then giving the defense time to respond to what they have to respond to by hiring what additional experts. But when the defense then hires additional experts, she cuts the defense off at the knees anyhow. So I think that this was an absolute, shall we say, well, no, let me put it what it is. I think it's a misrepresentation. This is not what he's been worried about. And if it's only he's been worried about, it's because he created the issue. He knew he was going to create the issue. And he knew that the judge then may say, well, then you can't have ARCA respond. And you can't have ARCA respond because if ARCA can't tell you what the direction is and who they were getting directives from and why they were doing stuff, maybe their testimony shouldn't come in. So they created this whole problem. And remember, she said it couldn't be dealt with until this whole issue couldn't be dealt with until after the trial because she was going to have a hearing just before they testified, granting the defendant's motion to have a hearing on whether or not their evidence was within Lanigan, right? Just before they testified. And so she created the issue based on what Hank did, which created the issue, trying to get the defense, giving the defense no defense. I think it's outrageous. I think it's irresponsible. I think it's terrible. And I have not been, as you know, one for like, let's say we're a free carry movement. We're at this network. We're on what can the prosecution prove beyond a reasonable doubt. But in doing so, you have to give the defense the ability to rebut what the prosecution attempts to prove. All right. Instead of saying, I have grave concerns about what the defense is and having that carry over. And Hank Brennan knows that he's got this going. He knows he created this vibe. And now he's trying to come in and he's trying to hammer it home. And recall, after all that, right? And she asked for, the judge at the very end asked for, well, when did you get this? And when did you get that? And Jackson says, look, she said, look, I expect a report within 7 or 10 days, which is nowhere near to when they're going to testify in the defense case, right? So it's not like it's going to have anything to do with what the Lanigan hearing is or delay the Lanigan hearing. It's not going to delay anything because she won't let them testify until she has the Lanigan hearing. But now she may not need the Lanigan hearing because for the first time, Hank Brennan says, whoa, I was never not seeking them the ability. I was never not preventing them. I was never not motioning for them not to testify. Yes, you were. Yes, you were. So this is to me, and this is why I had to mute myself before, because I was saying bad words I should not be saying, all right? Because I've been through this when prosecutors try to do this, but you want a judge, this is what you want a judge to stand up and say, look, and she did say something earlier on about Hank Brennan on the dog bite thing having an uphill battle, but that was it. I mean, you need her to stand in and say, look, Mr. Hank Brennan, Mr. Prosecutor, because let's call him now. He's the prosecutor, right? Mr. Prosecutor, you submitted a report in January, late at night. Defense read it February 1st. She didn't have it really complete until February 5th when they had defense saw it. The defense immediately filed a motion that this report should not be allowed. There should be a Lanigan hearing, that it was overbroad, that they were trying to usurp or get around the fact that the prosecution doesn't have a medical examiner to have a manner of death and all. And we had all sorts of arguments on it and clear in court. I wouldn't give the hearing, but then, I said for you all to work out the PowerPoint issue. And so, the defense has a right to have their experts respond to that. Matter of fact, quite frankly, they would have a right to have an expert go out, hire a new expert, in my opinion, to respond to a brain guy, if they wanted to hire another brain expert to respond to a brain guy to say that's wrong. So instead, the defense is like, okay, we hire them directly now to respond to Wexler. All right, we hire them directly to respond to this, and they're going to have a report. She says, what, in 3 days? No, as soon as they have the report. And what the defense is clearly showing is that they're not going to control what ARCA thinks that they should do to test or make testing in response to Wexler to show that he is not, his report is not accurate. All right, his brain surgeon argument and all his report is not accurate. So clearly, they're trying to maintain that ARCA is totally independent. Although I'd want to know what they're doing if I'm hiring them and I'm the one responsible for paying money. So that's maybe that was the decision that Alan Jackson made. I mean, I don't know if I'd make that. I think I'd want to know what they were doing. I wouldn't direct them, but I'd want to know what they were doing. But so they're going to have a report that's then going to respond to what Wexler is going to testify. It's going to be obviously done in advance of what Wexler is going to say on the stand, right? She's clearly not pushed. She's clearly not eliminated him from testifying for the prosecution. So what's the big deal? Judge, rule that there's no problem. Defense can do it. As soon as you have that updated report, you give it to the prosecution and we'll deal with it at any time at the hearing that I've already ruled that we're going to have before they testify. Okay, it's as simple as that. It's very. This is not, excuse me for the pun, brain surgery. Just not brain surgery. It simply is not brain surgery. All right, so that's where we last left it. She just took a break, and there's also other things. Obviously, we have coming up. We have Aiden's hearing, but it turns out that the 45 statements that Hank Brennan said he provided. Well, he didn't actually provide the video of the ones he's going to use. He just said, "Here's the 45 I want to use." But she's making them. Elizabeth Little kind of gets what she wants with regard to that. And we could go back through the dog bite, but I see that joining us from I think it's a place you have a press pass. That we have a press pass. Okay. Center Street, the big court in New York City. Are you ready to actually join us, Michael Bryant? He said he's set up. There he is, okay? I have been on a rant since we took a break 5 minutes ago. This has been unbelievable this morning in my view, as you know, I've always been very fair to Hank Brennan, but today it took a turn and I have had enough with it. I mean, come on. And if the judge gives, well, we lost him again. Maybe Hank Brennan knows we're bad mouthing him, and somebody's on us. I'm just kidding. I had to make a little joke with regard to there, but I really just think that I'm not tolerating this anymore. I'm not tolerating this bullshit, and the judge shouldn't be tolerating this, and that's the problem. She's the only thing that can tolerate this. Okay, let's remember. This was all about not having ARCA testify because it doesn't support the prosecution's case. Everybody in the government, whether it was the actual medical examiner, the forensic pathologist that's been hired, whose testimony really we should review, who said the same thing, that those wounds could be dog bite wounds, that certainly there's no indication that a vehicle, a large ton vehicle struck John O'Keefe and hit and killed him, that neither of them could call this a strike by a vehicle. Neither of them could call this a homicide. And then ARCA comes in and they want to say that they want the judge won't let them say, even because they aren't medical experts, that the cause of death wasn't a strike to the vehicle. Yet she's going to let some kind of dog bite expert say it for the prosecution. And we talked about the dog. There was another dog bite motion earlier with Wing and all. So let's say that this time is really outrageous. If the judge doesn't come down hard on Hank Brennan from this, he's going to feel that he has total room to run. And absolutely, I think there is a real not control of the courtroom and and a bias here at this point. I'm going to say, yes, I didn't think the judge was biased, but I now think the judge is biased in favor of the prosecution for whatever reason. And I think it still goes back to that Hank Brennan created that grave concern issue with regard to this. Now, let me just go back because I have a lot on ARCA, okay? ARCA here, which we've always talked about. And even last night on our show, we talked about that was the one outstanding motion. Let's go back to something as Michael Bryan, we lost him a little bit, sets up. All right, let's go back to the issue of having readers, right? Hank Brennan wants to have on the texts that are read, that are found, a reader come in, an independent reader. Oh, independently, a state police officer who's not connected with this case come in. Sure, they'll be independent. Let me tell you about independent readers, because I'm brilliant and skillful at this too. I know this game that's being played. When you have, for instance, depositions being read in court that somebody can't testify, and your people get on the stand, they read things with inflection. Now, Hank Brennan said there's going to be no inflection. I don't buy that, all right? Ron Kuby, great trial lawyer here in New York City, he hires actors to come in and read transcripts so that they have not only inflection, but they have meaning and tone in terms of everything. But Hank Brennan, for some reason, doesn't want the officer who found the text, Warino, to come in and read all the text. Doesn't want him to come in and read the text. Wants somebody else, which means he watched the trial testimony and he didn't think, in my opinion, that officer did a good enough job for the prosecution and reading the text well, supposedly not with inflection, but reading the text in a way that was helpful to the prosecution. No doubt in my mind, because there's no reason to make a motion for an independent reader, okay? So, you know, while initially, and Jackson kind of dealt with this. He says, look, I said, why the person who found the text should be able to read what they found, right? The person who found the text should be able to read what they found. Absolutely no doubt about it. I mean, I found this text. I'm the officer. So what you're going to do? You're going to have somebody come in and say, all right, now you're going to get out of the chair. Here is state police person number X. And state police person is now going to read the text that they found. That is, he's got something up his sleeve. And up his sleeve meaning that he didn't like the way they were read in the first trial. He didn't think that it was helpful because he had to keep saying, but the independent reader is not going to read with inflection. No inflection. There won't be any inflection, right? You know? So he's got it up his sleeve that he wants an, quote, an independent reader that's going to read something with more, may not be inflection, but it may be more forceful, right? It may not be an actor, but it's going to be somebody who's going to have read them to Hank Brennan, and he likes the way they read them. Come on. This wasn't, this was, you know, I think we may be back in court, actually, before Michael Bryan gets on. So why don't we go in court? I'm just going to mute myself.
Court is back in session. You may be seated.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay.
Work.
All right, were you as well, Ms. Little?
Yes, we were able to see the video and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
It's not.
Okay, all right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out, all right?
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So
This is the Aidan Kearney motion
you have
to
that.
exempt him from the sequestration order because Hank Brennan has put him on the witness list. And therefore,
All right.
if he's
I probably
sequestered
have
as
it
a
here,
witness,
too.
he can't cover the trial, taking away his
I have one,
his
too,
rights to be a journalist, taking
All
away his
right,
income.
I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Brado. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right, now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Carney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute that seeking to contact witnesses, seeking to question people is witness
Okay,
intimidation.
so just focus back on.
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
Oh, I'm sorry.
But that's okay. I don't want to hear about
Got
the
it.
witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and, I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradle.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, I would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But
And
as a predicate, he would need to assert his fifth.
do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradle, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradle, or not? Do you want to talk with your client? And
7 minutes.
sure. Why don't, you know what, I'll give you more than a minute, Mr. Bradle. Can the staff work through lunch for a little bit?
Yes.
Everybody stay? All right. Mr. Bradle, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
All right, let's talk about the last thing we just heard, because Michael Bryan and I did discuss this on a prior show. We're going to have to see whether or not we can go find it. And I specifically said that Hank Brennan was going to make Aidan Kearney get up there and assert the Fifth Amendment. All right, because there's when you are under indictment for witness intimidation, which I don't think any of the things he's under indictment is witness intimidation, by the way. I think is, again, I'm going to use that legal technical term, bullshit, okay, with regard to this. And then you put him on the witness list, knowing that you're likely not going to call him, knowing that you probably can't call him. And then the judge asks you, well, are you going to have about something else? He said, well, we may call him in rebuttal if the defendant testifies. You know, there's no likelihood in hell the defendant's going to testify. But he did have to agree, because he had no choice, that if Aidan Kearney takes the Fifth Amendment, he can't use the sequestration to keep him out. Okay. Now, here's the absolute rub, and here's what really just, to me, is again outrageous. I said to you in the show we did, I'm going to try to find it. I said, look, usually a judge in this circumstances, because this is not, we're not talking about a major case here, will allow an attorney to assert the Fifth on behalf of the client in this type of circumstance, so that the person doesn't have to get up and embarrass themselves or say, I'm taking the Fifth Amendment, blah, 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 right? Because it's one thing if you had like an O.J. Simpson case and you have Mark Furman come to the stand and he has to be on the stand and not testify out of the presence of the jury that he's going to take the Fifth, okay? That's a different story. That's because you're actually in the trial. But here, you're not in a trial. You're looking at a sequestration order to be exempted for, right? So what they want to do, they think, this is what's in Hank Brennan's mind. They think somehow if they get him up there, even though it's not in the presence of the jury, right? And he gets up there and he has to assert the Fifth Amendment, and I don't know what Brendan's going to ask him, or what the judge is going to allow, whether she's just going to get around this and say, are you going to take the Fifth Amendment if you're called, or ask Bradel to do it? But usually what happens is the prosecutor asks, are you going to take the Fifth Amendment, right? It's usually outside the presence of the judge, if there, even if there are cameras, and we've had this done in other cases, so that you can't have that clip, okay, that's going to run over the news media. People say, well, because you're taking the Fifth Amendment, right, because you're doing that, you must be a bad, bad person. You must be guilty. You're not supposed to infer that. But that's what Brennan wants. He wants that. He wants that clip. He wants it run all over the news media. He wants it over and over, and he's hoping that the jury will see it. That's what he is looking for, okay? Because there's no reason to have this done, because we're not in the trial. Sometimes you can have it brought at sidebar. In Hernandez, we had people brought up at sidebar, the prosecution, and they did the whole fifth inquiry by the judge at sidebar, right? So that it wasn't on the record and all. It wasn't on the record. You can't do it, and you can't take the Fifth in front of the jury, okay? Or if you are, it's because somebody asked a question they weren't supposed to. You're not supposed to be doing that. If you know they're going to take the Fifth, you're not supposed to bring them up in front of a jury and ask the question. But you can do it at sidebar so that you don't have all those clips running. And then, and that's a lot of times that's done if you're going to give testimonial immunity to a witness in a case that you want their testimony, but you're going to give them testimonial immunity. But my point is, there's no reason for this except for Hank Brennan wants salaciousness, and he wants to have him on the stand, and he's hoping that he gets to ask the question as opposed to Bradel or the judge. And irrespective of that, or is it irregardless? Or irregardless is not really a word, although I think they just recognized it in the dictionary. Regardless of that, he wants that all over the news media. He wants that clip. It's like when the prosecutor wants to have your client hold the gun they're accused of shooting somebody with, and you're like, time out, objection. You go to sidebar, and no judge will allow that. What are the prosecutors looking for? The salacious clip to be played on the news media. So I say to you, we called it. We said when we did this show weeks ago that Hank Brennan, if this was going to occur, that Hank Brennan was going to ask for that. He was going to ask that Aidan Kearney take that, get on and take the Fifth himself. That he was going to do it because that's the clip he wanted. All right. And it certainly turns out that that's exactly what he is going to do. Okay. I think it's ridiculous. I think it's outrageous. We all know that Hank Brennan was never going to use Aidan Kearney. in this case. Never, ever, ever. We all know that these charges are going to go nowhere eventually because no one is going to convict for having rubber duckies or having a car pan or being in front of a pizza parlor where you're not supposed to have cameras that can hear you and doing schoolyard stuff like that. And it's a sideshow, but the prosecution wants the sideshow. All right. So I've been really pretty even-handed on this, but I think this is ridiculous. I think this and the whole ARCA thing with the representation today that Hank Brennan didn't want to have ARCA not being used, and then the whole trend, have an independent reader. You can't be the person who found the evidence. Read the text that you found. We want an independent reader. Well, you tell your reader just you don't have any inflection, and your police officer should be fine, as opposed to another police officer. And remember, this is today to me is really one that really turned me from being really saying to all of you, be fair. He's doing a good job. Well, yeah, he's doing a good job if you want to get it convicted underhandedly, in my opinion, Mr. Brennan. And I'd love to speak to you afterwards, because I do think you're a very good lawyer. And you're probably a really good defense attorney and all. But this is not appropriate. This is not right. And the problem you have is a judge who's not stopping it, okay? You're not stopping this at all. It's really ridiculous. And we haven't even talked about Chloe yet, have we? Okay? We haven't even talked about Chloe yet. This whole idea, and forensic science is what I do, okay? This whole idea that you can take a mold of a dog years later. First of all, your dentition changes, whether you're a dog or your person. Second of all, forensic odontology, matching bite marks to a person, it's been like undone almost everywhere except for like a state of New York, where some judge upheld the issue of a forensic bite mark being valid evidence. But there's been more people that have been set free on wrongful convictions for wrongful bite mark evidence than you can imagine. Just go to the Innocence Project and you'll find out. I'm going to actually try to find Chris Fabricant and try to get him on our show one night to talk about this. The National Academy of Sciences Report 2009, Strengthening Forensic Science as a Path Forward. I have it over here. I think I showed it to you one day. That talks about how forensic odontology is not a science. Now, it is a science when you're matching teeth for people, like there's a plane accident, plane crash, and you want to see if a body has the same dentition on teeth, because your teeth, your fillings, you have x-rays, and, we all, not all of us, but some of us have fillings in our teeth or have had braces or a tooth overlap, and that's different. But also in forensic odontology, you can't match because skin moves. Skin is movable. It's pliable. So if there is a bite, just because you've measured something or you've measured doesn't mean because skin is pliable that a mold or anything is valid. I mean, I love Robert Leslie, but I think he should be going after that. It's not valid in any situation. There's no protocol that makes a forensic odontology and a bite mark. And what Hank Brennan is trying to say, well, it's exclusionary to a dog. Well, it's exclusionary maybe if you have a person, but even then it's not allowed because it's not allowed as a valid science. Exclusionary to a dog, that's even worse, because exclusionary, there's not been many studies, I'll guarantee you, on whether or not there's been forensic odontology studies, validation studies, error rates, peer review studies on having forensic odontology applied to a dog. Now, there was a big issue, and you can Google it, in Canada about 25 or 30 years ago, where a medical examiner caused people to get convicted, mothers to be convicted of murder of their children, because they found out that the mothers had beaten the child or taken a blunt force object and hit the child or whatever like that. And it turns out that a bunch of them, I think there were at least 3 of them, by the same forensic pathologist, were all caused by attacks. I think a pit bull was one of them, but all caused by dog attacks, because you can tell that their dog bites. You can tell there's dog scratches. You can tell that. But you don't necessarily measure the dentition years later with a mold by a dog that you don't even know is the same dog, supposedly a Chloe, because remember, they don't have any DNA of Chloe. So that is another issue that I really had a problem. For him to get up there and say, well, it's allowed because it's exclusionary, he knows damn well it's not. He knows damn well this is not a science. Okay, Hank, challenge me on this. Come on the show when you're finished here and we'll talk lawyer to lawyer. Now, that doesn't say that he's not going to get a conviction on something. I mean, I don't know. I don't know what he's going to prove or not prove. But this kind of bullshit today, excuse me, it's the same legal technical term. Well, you guys have to give me another legal technical term for that. You know, when I say you've got them by the, I usually say you have them by the sneakers, right? You know, and that one came from a client of mine who gave me that term, and she would always, because I used it in a summation, she, at the end when we won, she gave me a pair of sneakers tied together. So I always had those in my office for a long period of time. So we have Chloe, okay. Then we have what else was it that was really that rankled me? Well, Welcher. How do you pronounce his name? Welcher. I think there were two different pronunciations this morning, and I was like, all right. I thought I knew how to pronounce his name. Why are everyone pronouncing his name differently? But, you know, Hank Brennan tends to do that with prosecution experts, just like he tends to pronounce the names of people differently than actually is their name. Okay. Oh, let's go back to the logistics view. Let's go back to that view. We stopped talking about that because they came back from a break. And that was the whole idea of the sidebar. Yeah, one said wing and one said ring. Okay, doctor. Every time if the defense called their expert what he is, then Hank Brennan would call the expert ring. You know, I mean, I was like, you know, is he trying to gaslight us all? Here's the thing: the whole view. All right. And forget the fact that they want to keep it secret. Forget the fact that you know, they're so cheap they can't hire two buses. Forget all that. Hank Brennan absolutely had objected to the SUV of Karen Reed being outside at Fairview. Absolutely objected to it. All right. Absolutely. You go back, you'll see it. All right. Today he said, I never objected to that, or I did object to it. You know, but you know why I objected to it? Because I thought it was unfair to the defendant to have the defendant outside Fairview. I thought that was simply unfair, right? I thought it was unfair to the defendant. The defendant wants it, right? The defendant can say whether they think something is unfair. All of a sudden, he had this great concern that the defendant, that he was concerned that she get a fair trial, and therefore he didn't want the SUV out there because it would not be fair. It absolutely would be fair, because when you see, as Michael Bryan did the drive-through, that's all on this, right? As Michael Bryan did the drive-through, that's all on this, right? You know, you see how small it is and how big her car is. Somebody's doing 5 miles an hour. I mean, give me a break. And also, the defendant wants it because it's helpful to her case. And all of a sudden, Hank Brennan was like, oh, come on. You know, I wanted to be fair to the defendant. That got me. All right. That was another thing that got me today. So I was pretty pissed off about that with regard, because he absolutely did say that. And we reported on it that car should be out there. You can have a jury view. When we had Hernandez, and I only bring up Hernandez because it's Massachusetts. You know, we had the jury view. We had they could go look at the car that Aaron was in, and allegedly that the shot came out of, right? Jurors were actually sitting in the stuff. They were seeing for themselves. We went to the nightclub. Everybody was there, you know, seeing for themselves. I mean, you can do these things and you can do them right. And you have everyone there. And the only reason we didn't have Aaron there is because he was in custody, and bringing somebody in custody with, you know, leg irons and chains and you know, prison officials, that made, to me, that would have been unfair to our client. But they went and saw everything else, and they saw everything we saw. They could measure. Well, they couldn't measure because that would be a testimony. But really, I mean, I don't understand. It's like we're you know, Judge Canoni, remember, was a defense attorney for like 24 years, 27 years. She was defender services and all. She's been through this stuff. I mean, I don't understand about you know, letting Hank Brennan get away with this, because if he gets away with this now, you know what he's going to get away with in trial. He's going to get away with a lot in trial. Now, they did apparently agree on a video clip that Hank Brennan wants to play in his opening. It sounds to me that it may be a video clip of a compilation of Karen Reed's statements, which apparently she stands by and all. So, you know, if there's statements they can use, every time you use a defendant's statement and it turns out it is not helpful against the prosecution's case, it then eliminates further the need for the defendant to testify. Quite frankly, the worst thing that the judge did for the prosecution is enter a gag order. Why is that? Because Karen Reed has been talking to the attorneys. Now, Dizzy, I know you say the clips contradict each other, but let me tell you what's going to happen here is defense is going to then put them in perspective, okay? They're going to have more stuff, and they're going to say, no, when prosecution tried to mislead you. I know what's coming by putting these clips together, but if you take them in perspective of their own interviews, they were not, okay? So that's what's going to happen. I know exactly. Let me tell you, I know the game plan here, and that's why defense is not going to object because she made the statements. But they're going to go after the prosecutor and have the jury believe the prosecutor is trying to pull the wool over their eye because in terms of completeness or in terms of complete interviews or in other interviews, that those were not different. Okay, so this is the game that's going to be played. And if you're a prosecutor and you open with that, that's always it's a gamble. Okay, it's a gamble. That's definitely a gamble. Okay, so I mean you have to wonder. You have to wonder here. And remember, he's got a lot of people also behind him doing things, just like he accused with a clip. He accused, shall I say, was it Yannetti? Yes, he accused Yannetti of giving an interview in violation of the gag order on Court TV. And it turns out all Court TV ran a clip of a hearing in a report they were doing that ran after the gag order. And why did that happen? Because somebody in his office or in that office put that together and told them, well, this was Yannetti violating the gag order. Same thing with a lot of these clips. While he's looking at them and all, I'll guarantee you the defense knows more about what their client said than the prosecution does. And they didn't agree that these clips were valid for no reason at all, because they didn't fight here today with regard to these clips at all. Now, will there be a fight later on? Maybe if there's something else that comes forward and it's not in completeness, right? Maybe there'll be a fight later on. But we also, by the way, learned that there was some slides that were PowerPoint that were removed from that, that 140-page PowerPoint. Again, I guarantee you, okay, 140 PowerPoint slides. Now, sometimes I give a lecture a lot of times with 140 PowerPoint slides, but I'm talking through them. They're going in the background. They're behind me. When I close on the Phil Spector slides, we had probably 140, 150 PowerPoint, but they were running behind me, right? They're running. It's like a silent movie running behind you, and then when you want to turn to one, you can't. Okay, stop it right there because you have your unmuted. You have your motions. And there, by the way, let's go back into court.
You may be seated.
All right. Mr. Brennan, do you agree that Mr. Carney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Carney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Carney to assert his Fifth.
I thought you wanted a basis. No, I'm going to see Mr. Carney here at Sidebar with just you, Mr. Bradel.
Thank
and
you.
All recording devices are off.
Thank you.
FTR goes to sealed, Tori and Chrissy.
All right. So what did I tell you? All right. Having done this, I said a judge can do it at sidebar. The prosecution wanted him on the stand to take the privilege. The defense then, Hank Brennan acknowledges his Fifth Amendment privilege, tries to weasel out of it about, oh, maybe not all the questions I have. Brado says, look, Judge, take judicial notice of it. And you can take my representation. The judge said, well, I'm going to do it at sidebar. But there's going to be no recording devices. And because it's sidebar, guess what? We don't get that view, do we? So for the first time, I'm very happy with Judge Canoni because she's doing it right. This is what I told you. It can be done at sidebar. It can be done out of the presence, and the judge can do it in no circus. All right. And I'm sure Hank Brennan right now is shedding a few tears because what he tried to do was have Aidan Carney on the stand there today, and it did not work. Okay. So he can say he's taken the Fifth Amendment privilege, but of course he has a right to take the Fifth Amendment privilege. He recalled. Whoops, Here we go.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Carney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the 2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me? I have not had a chance to read them. All right, this looks like you all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy and
And it is something that we've done.
right, understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All rise for the vote, please.
Okay, I think I'm on the stage with you again. That's the end for the day. So I guess the Commonwealth didn't get what they want. It would have been very simple. It would be very, very simple to have just had the sequestration order not apply to him. But Hank Brennan tried, and he tried, and he tried, and he tried. And maybe Judge Canoni's heard all of us talking about how it's ridiculous not to exempt him from the sequestration order. I understand he's going to be talking about it tonight, Turtle Boy, on his show at 9 p.m. We do, by the way, have a couple of questions that I want to talk to you about. And Michael Bryan did, we couldn't get the Starlink really to work, but he did do a report from the field of Weinstein. And I'm trying to see if we can upload it now and play it so we can give you an update on the Weinstein. Missy and Dizzy, I know Michael just texted me that he sent it to you. But while I review what happened today, maybe we can find that so that we can play it right now as an updated report on what's happening in Weinstein. Okay. All right. So, Last word, Aidan Carney will be reporting on this case, except he will be to be allowed in the courtroom when the alleged victims of tampering with witnesses are on the stand and the 2 minors. Okay, same thing as before. So he will be allowed to be reporting on this. He will go into
Lori Daybell,
already convicted for the murders of her children.
Doomsday Cult mom is now lawyer. Lori,
she's
representing herself.
I'm
charges of
hearing a
conspiring
bunch
to
of
murder
stuff.
her 4th husband.
Is everyone hearing
said
what I'm
fucking
hearing?
murder
Because
you
right
now.
here I'm hearing about Lori Daybell, and I don't think that's what we're trying to play. Okay, sorry about that. All right, so that's apparently how the person who was the network that was the network for being in the courtroom there was doing it. So sorry about that. But we're trying to upload. I'd like to have Michael Bryant's clip that he sent uploaded, please, if we could. And anyhow, so here's the synopsis of what happened today. We don't know what the judges ruled, okay? Because she hasn't really ruled. She said she'd let them know by tomorrow. At one point, she said, if I have to bring you back, I'll bring you back. But I don't think that's going to happen. We have a lot of issues that were discussed. We have the view that was discussed of the scene on Fairview that they're going to go to. We don't know when that's going to be. However, we do know that Karen Reed will be allowed to be there. She will go in a separate automobile, separate car, separate SUV with one attorney. And that's her right to be there. It was just the logistics. And of course, she wasn't going to be on the bus with the jury, but she will go in a separate, and she will be at that view when the jury is there. And sometimes there's a court reporter there and sometimes not. Massachusetts, my recollection, did take a court reporter. Some places do not take a court reporter. Some places allow even jurors to ask questions at a view, and that's why court reporters there. Other places do not. I do not know what the parameters were the first time. I'll have to look it up to see, because I assume it's the same parameters on the second time. We were talking about, we started today talking about all, the first thing actually was the filing of that motion, because apparently Yannetti had to leave, and local counsel Victoria George, who was the alternate jury and the juror in the first case, came in to then sponsor the outside attorneys. That was just a technical issue. It didn't really mean much. But as Yannetti left, there always has to be a local counsel in the room who has a sponsor in it. So, okay, so we understand that Michael Bryant did a report from the courthouse. And what I'm going to do is, why don't we play it on Weinstein, then we'll do a quick summation of Weinstein and what happened with Reed. And then I will let you all go to get ready for our 6 p.m. show, where we'll be on the air again tonight. I believe we set it for 6, right, Missy, if I recall? Because Michael then has to get back from the courthouse and all. So why don't we listen? It's 6 o'clock tonight. So why don't we first listen? This is Michael Bryant at the courthouse at 100 Center Street, where he was able to get into the courtroom with our press pass.
Okay, hey, Linda Kenny Bodden. Yeah, down here at 100 Center Street, spelled C-N-T-R-E, because we're very British originally. And so I've been looking in on the Harvey Weinstein jury selection process for his retrial, which they now think is going to begin next week, maybe Monday or Tuesday. Does any of this sound familiar? They're in the middle of selecting jurors, but technically they have 0 at the moment. So let me give you some scene setting info to contrast this with what we've been going through with the Karen Reed case. Big courtroom, about, based on my calculations, and this is not smushing people together on the pews, I'd say 120 people could easily fit in this courtroom. And you've got 16 in the box right now as part of the veneer, and you have a few others, potential jurors scattered around in the gallery itself. And what they've been doing is taking each of these folks one at a time back into the inner sanctum. There's the doors in these courthouses, the interior part of the courtroom. It looks like paneling, looks like, the hidden door. So they've taken these folks in and out, and they're going in there with the attorneys, with the judge, and in the case of Harvey Weinstein, with jury consultant Joanne, I always get her last name wrong, Demetrius? Anyway, one of the preeminent jury consultants in the land. Obviously did OJ, was not involved in the first Harvey Weinstein trial, but is now front and center in part 2. So I had a chance to talk to our buddy Imran Ansari, who is on the defense team, to get a sense of where we are and what's happening. And although they haven't officially put anybody in the box, I proposed this possibility. Every judge is different in how they do this. It seems to me this judge operates by a function of exclusion. I've seen him exclude at least 3 people, and then they put new ones in the box. It seems to me that once you've had individual voir dire, and they don't excuse you, then there's a pretty good chance you're ultimately going to be on that panel. You will just not officially be impaneled. So that's a possibility. That's why they expect to have a jury in 2 days and have openings next Monday or Tuesday. There may be a day of wiggle room in there. But certainly a very different process than what we've seen happening up in Dedham, where the jury was impaneled very specifically one by one, and we knew day to day where they were with the process. So today, in the Harvey Weinstein retrial, officially no jurors, but I think they're making some progress following the process I think they're going to do. So let me give you a sense of, I know LKB always very interested in the racial makeup of prospective jurors here. Of the roughly 35 folks that are in the courtroom at the moment, there are about, let me see, I actually wrote these down because I knew you would be very interested in this. There were 3 African Americans, and this is again takes into account the 16 in the box plus the roughly equal number or more sitting scattered about in the gallery. There were 8 what I'll call non-white, and then the balance were very white. Men to women, almost a 50-50 mix at this point. What the jury consultant's looking for, very interesting. We don't know, but she definitely has a method that has worked in the past. One of the things we talked about a couple of days ago with both Imran Ansari and Arthur Aidala, 2 of the attorneys on the team for Harvey Weinstein, was this attempt to get Mr. Weinstein moved to Bellevue during the course of the trial. He is now in Rikers, not really where you go to rehab. He has cancer. He has diabetes. He's got some issues. And so this is not an unusual administrative request to have the defendant housed in Bellevue, which is not too far from here, as opposed to Rikers, which is a process getting in and out of every day. That accommodation, while not officially rejected, it's an administrative request. It was not rejected, but it's been sat on for a time. And so it's kind of like a pocket veto, you know. They're doing nothing. So what has just been filed, and we can post this document later in the day, is an OSC, order to show cause, why they have not allowed this administrative relief to move Harvey Weinstein up to Bellevue, the hospital near here, versus maintaining him in Rikers. So both for the medical reasons and for the convenience of getting a defendant to and from court with those medical conditions as an overlay. So we'll see. That's going to have to be argued and heard, and it's probably not going to happen before this trial gets underway. So we'll see how that goes. Harvey himself, looks like you've probably seen him most recently, head shaved. I was surprised he's sitting there at the defense table quite often by himself, because remember, the attorneys are back in judges' chambers with the prospective jurors. And I know the Linda Kenny Bodden rule is never leave your defendant alone at the table, and they are in fact doing that quite a bit. And so these prospective jurors who are looking right at him, his table here, the jury just off to his left, they got nothing to do. They're just twiddling their thumbs and, checking him out. I heard that yesterday one of the jurors was actually very surprised. I couldn't tell if it was in a good way or bad way that Harvey Weinstein was the defendant, and that this was that case, right? So they're checking him out. There's not much else going on in the courtroom to check out, and so there he is, kind of sitting for the most part by himself. They're going to continue the process. They went late yesterday. They went to almost, I think it was 5:15, but they're trying to get out of here at 4:30 each day. I'm guessing that as this week ends, and depending on how the progress is going with getting the jurors they need, that time may flux. But for now, they're giving the jurors the heads up that you're going to be here pretty much all day. They have a lunch break that is just about to begin, and then they'll go back at it. So that's about it from here. I think it's going to be very interesting in this round two for a number of reasons. And defense counsel for Mr. Weinstein talked about it at Justice Serve TV exclusively just a couple of days ago. there's a third new claimant, and all I can tell you about that person is it's not a famous name. It's not like Miss Shiora, Annabella, the actress. Not an actress, not a name, not a face you'd recognize immediately. Obviously, we're going to get to know this person a lot better. But this is a claimant that apparently has some history with the defendant in the entertainment world. I know these are all vague references, but they really can't reveal much more than that now. It will become apparent soon enough. That, combined with the original two defendants, complainants, means a much tighter case. Yes, they're adding one, but remember, they're losing about 5 that were testifying in trial number 1 and ultimately led to the reversal and new trial because the court at the appellate level said, look, you can't have all these bad character from remote meetings and very different circumstances with Harvey Weinstein. So that's what the fair trial thing is all about. Crazy idea, I understand that. And certainly not a popular thing for those who hate Harvey Weinstein, and there's still plenty of those. So the difference in the number of claimants, the difference in the number of witnesses, and the fact that we're 5 years post, the crazy, rabid Me Too movement. Not that it's a bad thing, it's just that the tone is different now. And I think these attorneys are aware of that, and as they continue to pick a jury, that's certainly going to be weighing on their minds. Who's still clinging to that really intense feeling about Me Too? Because there are people that are still very intense about it, and perhaps they have reason to be, and perhaps they don't want them on the jury for the defense. Anyway, so that's going to do it from here. I'm going to pack it up, and I will head back to the home office. We'll see you a little bit later on tonight as we go back again live. We'll see you then.
As always, Michael Bryant, right on target. That's the report we try to give, but we were having trouble with the Starlink, but we were able to upload it, and we'll probably run it again later. Well, actually, we'll run Michael Bryant later. Joellen Demetrius, I worked with her. She was our jury consultant on Jason Williams. She also worked with Richard Gabriel when they picked the OJ. She and Richard Gabriel picked the OJ jury together, and she was recently... she knows New York City because recently she was a consultant for the defense in the Daniel Penny case. Okay. All right. So we know all the parties. If you want to hear our interview we did with Arthur Ardala and Imran Ansari the other day, it is on our Justice Serve TV page about, what they're looking for, how they believe this jury pick is different than the last jury pick, why it's different, and how they plan to defend the case. All knowledge they gave to us in an interview they did with us the other day. So please go back to Justice Serve TV and look at it. So before I leave you, let's just sum up what happened today. There's a couple of things we didn't talk about. That was defense motion to reconsider the judge's denial of the defense's request to have their expert review the whole Canton police surveillance computer, because they believe that if they looked at all of the videos on the Canton surveillance recorder, they may be able to reconstruct some of the metadata on the videos that were handed over to them. Remember, what happened is that the defense didn't know this because the videos were, all these Sallyport videos and all these Canton videos were given after the trial, in the trial, all of a sudden they were discovering more and more. It turns out that only one person was in charge of them, Sergeant D.M. Pietro. He retired like 2 days later after he gave them over here in this case. And all he did was he dragged and he dropped them to a USB. And once you drag and drop videos from the main source to a USB, it eliminates all the metadata and other stuff that you can find. Now, they must have known that. I mean, if you're in charge of forensically and making sure videos are there, they had to know that. So that's something I'm sure the defense will probably argue was done on purpose. But the defense wanted to get back into the whole complete video system because their expert said he may be able to get some dribs and drabs to see what the metadata was. There was no ruling from the judge on it today. She denied it once. I doubt that she was going to grant it. She's going to grant it again. As you saw, we were in the, by the way, as we were in the Sacco and Vanzetti courtroom today, we learned that the prosecutor, Hank Brennan, for the Commonwealth, is no longer going to object to the Lexus being brought to 34 Fairview. Previously, he had objected. He said because he didn't think it was fair for the defendant to have it brought, but he's changed his mind. So I'm glad he's so interested in Karen Reed's First Amendment and due process and Fifth Amendment rights. Okay. Then we've talked already about Chloe. He wants to have Chloe testify as a matter of exclusion, not Chloe, but Chloe's mouth. Chloe's mouth moles testify that has excluded her from being the person dog. My dog is like a person. I mean, you see my poodles and my dogs all around. I love my dogs. Would be the one who allegedly attacked John O'Keefe if the defense goes there. The judge did say one thing. She did say, well, you have an uphill battle on this, Mr. Brennan, because the National Academy of Sciences simply doesn't recognize this. This is, shall we say, incomplete science, shall we say, and it's been subject in humans of having a lot of wrongful convictions. So we went through that. No ruling on any of these, by the way. That there was there. The media interviews being read in that there was an agreement. I think on that the clips were accurate. I don't know whether the defense is going to eventually agree that all of them will be accurate, but at least there's going to be there's going to be a video of a couple of clips of the media interviews allegedly where Karen Reed probably, according to the prosecution, would have said two separate things, but we'll see about that. Then there was a motion by Hank Brennan. He wanted an independent reader for the text messages. We haven't heard whether or not the judge is going to allow then. And then, of course, we went to the main one, the ARCA one. Hank Brennan said he never wanted ARCA not to testify, which is, as we all, bullshit. No way. This is what this whole fight has been about. This independent experts coming in. And the next fight is going to be about what they're going to be told. The jury can be told, because remember, the first jury thought maybe it was her insurance company coming in. Has a lot more weight when it's hired by the Department of Justice, the federal government, to investigate and come to an independent conclusion. And then now, of course, the defense has hired them to do a report to go against Dr. Welch's testimony about that the prosecution is bringing in. And they just gave their report on January 31st. They gave the documents on February 5th. And apparently new stuff is still coming, or new reports or updated reports are still coming. The defense says they're going to have a report in response to 7 or 10 days. And of course, Hank Brennan is objecting on the basis that that's trial by ambush. That's just garbage. I mean, that just this whole idea of righteousness that he had, I think today was exactly a little bit too much. And then we went to there were some minor other motions in between, but we went really to the end, and the end was Hank Brennan wanting to get Aidan Carney on the stand there to assert his Fifth Amendment rights, so he'd have a video of him, in my opinion. Okay, this is all my opinion. Everything I'm saying is my opinion. A video of him taking the Fifth Amendment and saying, see what a bad guy, don't believe anything he says, because we have an inherent bias against people who take the Fifth Amendment. We think they're guilty when they're not. They're just asserting the right of having the prosecution, asserting the right of having the Constitution of the United States of America, which is why we're all here in this country, be behind us and make sure we're not railroaded for any reason. Well, he didn't get that. Matter of fact, Aidan Carney should be very happy. Aidan got the sequestration order undone, and Aidan will be able to report from that courtroom, except when the alleged victims of the witness intimidation, I roll my eyes, are on the stand. And several juveniles. Okay, the defense had, Aidan Carney's attorney had no problem with that, actually. But Hank Brennan did not get him, despite his best, by putting him on the witness list, did not get him sequestered, and then did not get what he wanted today, which is that media clown show that he thought he would get with Aidan going on the stand. So the judge did the right thing, did what I said a couple weeks ago, can be done, go to sidebar, no cameras. The judge puts it on the record that he would assert the Fifth, and he has a right to assert the Fifth, even if he's innocent. And of course, we all think he's innocent because he's been accused of a crime. All right, it's simple as that. And so I think we all saw how disingenuous at the very end with those arguments that were made. And we also know, by the way, that Karen Reed can go to the View at Fairview. So those were, in a nutshell, those were things that happened. I think today was actually a pretty big loss for the prosecution. Why do I say that? Because in my opinion, I think all this stuff about, I was trying to be fair to the defendant. I didn't say that. I didn't want ARCA not to testify. I want Aidan Carney to say it himself. I want Aidan Carney to say he's going to take the Fifth Amendment himself, when he could have said, I take the representation of counsel. It's done all the time in every single courtroom when it's not related to a major criminal case. This is a sideshow on a criminal case with regard to a sequestration order. Okay, so I think that it was a big loss for Hank Brennan. And the one thing he did to me is, I've been saying he's a good attorney. Give him a fair shake. Yes, you could be tough. You could still be tough, and the prosecution deserves to have a good attorney. Maybe not someone they felt Mr. Lowley wasn't good. By the way, I'll never understand why Lowley will allow his dignity to sit there while having Hank Brennan try this case. If I were him, I would have gotten up and quit immediately. I don't care. I mean, I know you need to make a living, but a lot of people stand up for their principles. And boy, gosh, you should have been standing up for your principle and not letting you to be, shall we say, de-sneakered. Okay. But that's another issue, and that's not my issue, since it's not me being de-sneakered. Anyhow, that's a quick summation. I know I talked a lot. I think I'm going to go have a little more Dunkin', get my throat wet, do some legal work, and then start preparing for our show tonight at 6 o'clock p.m. I really want you, are we ready to portal over to that, Missy? I know, because I want to have you all be able to portal into that show. If we are, yes, we're able to portal. So, but before you go, okay, you know what I'm going to say. You have to hit the like button, please. I'm going to give you time. Like button, okay? Hit the subscribe, the share, the notify. And if you get a chance and you want to feel like having a little downtime, go to our shop. I'm in the shop every day. As Michael Bryan told you, I'm the biggest customer. Let's see, I told you I bought yoga pants. I bought a beanie. I bought some other things. I'm going to buy my husband the fleece pants, the merch shop. Yes, April merch. We were calling it Merch Madness because we were trying to get it up on March for the basketball. But Merch Madness, and you have to actually go to the shop. If you just go to what's on YouTube, you're only allowed like 30 items. I guess they don't want their computers clogged by people shopping. So you go to the shop and there's a lot there. Oh, I'm going to be able to pour my Dunkin' in like a mug that I can have a top on here so I don't spill it. Yeah, and all that. So take a look at it. Dizzy did most designing, and then I got to pick. Oh, my favorite thing, picking how I shop. Okay, you really just go and maybe you'll be comfortable watching TV in your Justice Serve and watching the new trial in your Justice Serve gear. And your merch and wearing. I wonder if you wore one of the little stickers through the zone. I talked to Michael Bryan about this, through that zone there, right? Whether or not we would be arrested. Is advertising Justice Serve TV, would that be in violation of the zone? Something I have to think about. And maybe I'll ask Michael Bryan if he knows the answer to that question. And by the way, we're still waiting for whether or not the court's going to give a TRO with regard to him. He won't be there, unfortunately, now for the openings, but he will be there next week with the lay of the land, because we've been there, 6 times now? And we are trying to bring you this case from the inside, not as a legacy media, but as your media. So stay with us. We're Justice Serve TV. Come back 6 o'clock tonight. And before you go, please hit that like button. And thanks to all the mods and everybody with me today, and you. See you later.
It's